Good morning and welcome to Legacy Planning with local attorney Steve Waltar. Legacy Planning is committed to helping you provide personalized and compassionate estate planning to help you organize and transfer your estate smoothly with minimal taxes, costs, and hassles. Steve has the mind of an attorney and the heart of a pastor, and he'd love to take your call this morning to answer your estate planning questions. The lines are open at 1-800-955-8200. That's 800-955-8200. Now, here's your host of Legacy Planning, Steve Waltar.
Good morning, people. I am live, and I will say I'm live, but I'm broadcasting from Sun Valley, Idaho. I would guarantee that it is cooler here than in good old Seattle and the greater Puget Sound. In fact, it's 21 degrees. It's gorgeous. Today I went out for breakfast, and I had trout Benedict, right? Instead of eggs Benedict, trout Benedict, kind of a local special. It was quite good at Conditori. So I missed you at Jimmy's on First today, but I'll be back next week. So since I am traveling, of course, we certainly hope that Rich will take care of business and we will be able to handle all the technical stuff and be able to take your calls because we would love to talk. We are live, and the toll-free number still works, 1-800-955-8200. That is 1-800-955-8200. But since I'm traveling and having a little vacation here, skiing, great day of skiing in Sun Valley yesterday, and we hope to go fly fishing today as well. That'll be really cold. But every time, how this relates to estate planning, of course, is whenever someone hops on the plane, especially the mothers with their minor children, they think, honey, we should do a will. And, of course, you should. And sometimes people ask me, Steve, is it valid? They kind of jotted down a few things on paper about who's supposed to take care of the kids. No, that's not valid. Not valid at all. Although I think anything you do in writing might be of some help or guidance, but it's certainly not valid. So I do lots of planning for people. Young couples needing to list guardians and set up the trusts to manage the money for their children. But also there are reasons to plan that involve trusts. So right now I'm holding in my hand a tube of toothpaste. And I like to analogize or use a tube of toothpaste as a metaphor for a trust. I think it was Oliver Wendell Holmes said, don't put your trust in money, put your money in trust. I'm not sure that was him, but we all use toothpaste. At least I hope we all do, right? My father-in-law was a dentist for 41 years there in the Wedgwood area. My wife was a dental hygienist. I know that I use toothpaste every day, multiple times. So a tube of toothpaste is like a trust. The toothpaste, if you squish it out, that is like the assets. The trust is the container. And so what I often explain to people is, tell me how you want the beneficiaries to receive things, and let's design a trust that's an appropriate way to care for that. And in this day and age, there are people that are worried about minor children. That's always been the case. You don't want kids at 18 to get everything. You want them to go to college or go to vocational school or get some training. And also, even a good kid at age 25, they may know a few things, but they haven't really managed money, haven't had to pay a whole lot of their own bills. They probably don't own a home, at least not in the Seattle community. That's freaking hard to do. So I like to say, let's do staggered. Let's keep it in trust to age 35. At 25, give them, pay for schooling, health, support, maintenance, anything they would need. Someone stands in your shoes to be the trustee, and they will look out after the money. And it's okay to have an advancement, a down payment on a home, or pay for college and tuition and books and all that stuff. And then give them kind of in staggered bits. Give them a portion. So often I say, hey, how about 1/3 at 25? And then by the time they're 30, then 1/2 of what's left in the trust. And then maybe at age 35, give them the remainder or the balance. That's a great way to kind of have a staggered distribution. That way, one bad decision is not going to blow up the entire trust. So that's kind of a good thing to do. But I think it's even better. Back to my toothpaste analogy. Why wouldn't you say at some point you hand the tube of toothpaste to the beneficiary? Let them be their own trustee. That's a good way to give some divorce protection, or at least some asset protection for the beneficiary. So, my wife and I, we have a revocable living trust. That's a whole nother kind. Now, I should give you a few terms. Every trust has 3 kinds of people. Trustors, sometimes called a grantor, but I just like to call it the trustor. That's whoever makes the trust. And for a husband and wife, you can both be grantors or trustors, okay? Trustees are the second types of people involved. They are the legal owner. They are the manager. They're the ones that get to buy, sell, lease, transfer, do all sorts of things. And the third kind of people are beneficiaries. And in fact, beneficiaries can be more than people. It can be churches, charities, children, grandchildren. So in our revocable living trust, my wife and I, we're all three people. We're the trustors, the creators, trustees, the managers, and the beneficiaries. So we, of course, list backup trustees. If we are unable, we list the backup. So anything you can do in a will, you can do in a trust. And it's a really nice tool. So again, don't put your trust in money, put your money in trust. The trick or I think the skill thing is to try to diagnose what kind of trust fits your needs. If you're not at all worried about probate or privacy, then you might be very appropriate to, like a lot of parents, they want to list guardians for their young children. And again, getting back to their hopping on a plane, they're worried they need to have some plan in place. They're nervous when they go on that trip. Well, they may not need a living trust. They may need a testamentary trust. Testamentary just means death. Not a very good term for a selling trust, but a testamentary trust means that it gets funded. Assets go into it when you die. So again, we're on legacy planning. If you want to call, you can call in the 1-800-955-8200. That is 1-800-955-8200. Or you can always send, it might be hard for me to check this remotely, but if you have a question, you can go to radio@waltar.com. That's radio, just like you'd think, at WALTAR.com, radio@waltar.com. So we're talking about trusts, and for people that want to have a trust to plan for their minor children, that can be a trust container inside of a last will and testament. It's called a last will and testament, a will, and there is a testamentary trust in it, meaning that when you die, yes, there's a probate, and I can explain the process of probate. It's not some big, huge, terrible thing in Washington. Normally, I mean, I've charged $3,500 for probate. I've also charged $35,000. So I won't say probate's cheap and easy, a trip to Disneyland, but it's not necessarily something to be feared or avoided. It's a fairly routine process. Usually takes between 4 to 12 months. I'm kind of going back and forth. It's just kind of fun to talk here and look outside and see the snow everywhere and the mountains and all that. So what topic do I guess I could go a couple ways. We're talking about trusts. What's the kind of trust that is, as an estate planning attorney, really when someone comes in, a single person or a couple, I am the heart physician or the surgeon. I do not even want to answer the question, does someone need a will or a trust or whatever, until I spend a lot of time just asking questions. I'm trying to diagnose what are the needs and what are the desires and things like that. So for some people, it's completely appropriate to have wills that have list the guardian for the minor children, and then you list a trustee, someone that will manage the money on behalf of the children. For other people, they would rather, I guess I should finish the revocable living trust, whereas a will takes effect when you die. If you hire an architect to draft up a blueprint for the home, that does not build the home. Think about it. It's the blueprint. It's the diagram. You have to actually hire the construction people. They lay the foundation and they build the walls and they put in electricity and stuff like that. So when you hire an attorney to do a will, or if you do your own will for that matter, and there's a lot of danger with that, but you can have a short or a really long will, but the will has no authority. It's just a blueprint. But when you die, you go to court. And you do a petition and order an oath, various pleadings. You notify creditors and the heirs and things like that. It's kind of the opposite plan with a revocable living trust. A revocable living trust, you draft it while you're alive, but you change title now. And so, for example, my wife and I we live in Kirkland. We have our home in our revocable living trust. And right now I'm sitting in our condo in Sun Valley. Now, there's 3 people that own it, but the percentage that we own, our 40%, is actually in our revocable living trust. And the neat thing about a trust is for married folks, you can put things into a trust however you like. It can go in as community property. It can go in as separate property. So there's all sorts of ways to do things. And this is really on my mind right now because after my breakfast this morning, I drove and I saw the little bench where we dedicated a bench to Glenna Rice. That was Susie's, my wife's mom. And so whenever we get here, we like to go by that bench and sit in the bench and take a look at Baldy Mountain and things like that. Well, the monies, some of the monies that Susie inherited from her parents when they were gone, at one point we had a place up at Birch Bay, but when we sold that, we were able to buy part, because it's expensive over here, part of a condo in the Sun Valley, Elkhorn area. And so we actually own this condo in our revocable living trust, and we did it as my wife's separate property. We protected her family inheritance. So in one revocable living trust, a married couple can own community property, separate property, all sorts of things. So this is really, really good stuff that you can do in a revocable living trust. I think I'll talk for a couple more minutes about trust, and then we'll take a break here. So don't put your money in trust, or no, I got it wrong. Don't put your trust in money. Put your money in trust. My wife and I just finished the Dave Ramsey class, Financial Peace University. So awful lot of talk about money and how do you value it. Money's got this way of sneaking out of your hands unless you have a plan. And it was neat a few years ago when a couple came in because they were told you ought to have a will. And for them, they actually wanted to pay a little bit more during their lifetime to get things in a trust and make it easier on their loved ones when they were gone. And because of the Dave Ramsey and the Financial Peace University, they had been saving up. They knew exactly that they wrote me a check when they did their plan. And again, my job as an estate planning attorney is not to put everyone in a trust. My job is to understand the goals, the wishes, and I can kind of give you some pros and cons, but usually within the first, half hour of a free initial consultation, I got a pretty good idea what sort of plan fits for them. So I'm in the business of building estate plans. And for this particular couple, yes, they needed a will to list a guardian for their minor child. But all of the money was to be handled in the trust, and that is private. So let me give you just a couple of benefits of a trust, and then we'll take a break. So a trust is, it's more detailed. You get to really check how you own things now and not only deed the real property and the business interest in, assign the LLCs and things like that. It's good in all 50 states. In fact, it works at many spots around the world. So you could own real property in all 50 states in the U.S. and have one trust. It avoids probate. It is private. It is harder to contest than a will. It can have many, many safety nets, like a trust protector, what we sometimes call a special co-trustee. It's a way to make sure that if something happens after the trust is formed or once it's being managed on behalf of someone else, you can have a trust protector come in, and that even makes it flexible to deal with life's changes. So, I would say there's generally three downsides to a trust. They're generally more cost up front, although I have a couple of attorneys in my own Rotary group. I won't mention the one, but it is in the Bellevue area. Bellevue, Washington, not Bellevue, Idaho. I'm kind of close to that right now. Generally, a living trust costs more. But not always. I will say the second kind of downside of a trust is it is more work. And this is kind of a sad thing about wills. A lot of times when attorneys draft wills, they don't look at what you own or how you own it. They don't change joint tenancy to tenancy in common or community property. So unfortunately, people are often lazy drafting wills. In a trust, it's more work. What do you own? How do you own it? And you get a chance to kind of, I often ask people, who knows your assets better, you or the next generation? Well, clearly you know your assets better, so why not get title cleaned up now? And the third, I would say, kind of downside to a trust is you got to remember you have it. You don't want to go the next 20, 30, 40 years of your life forgetting you have a trust. Now, it doesn't affect the way you do your taxes, and the IRS doesn't care you have one. You pay income taxes just like normal. But if you were to sell your home and buy a new one, it's good to remember, oh, yeah, we have a trust. Let's buy it in the name of the trust. And for our clients, we give a free review every 3 years, and that's, of course, one of the questions we have. Is there anything you bought that ought to be in the name of the trust? So we are going to go to a break now, and after we are back, we will talk about even more things at Legacy Planning.
Legacy Planning. Legacy Planning with Steve Waltar. Has it been over 5 years since you've reviewed your estate plan? Well, the laws keep changing. You'll definitely want to keep listening. The lines are open at 800-955-8200. That's 800-955-8200. Legacy Planning. Live and local. This is Legacy Planning with Steve Waltar. Wondering if you really have complete, up-to-date estate plans? Call Steve right now at 800-955-8200. That's 800-955-8200.
All right, so we are back. We're back after the break, and this is Steve Waltar, and I am live on Legacy Planning. I am broadcasting from Sun Valley, Idaho today, which is a lot of fun. It's gorgeous here. I hope it's good weather in the Seattle area right now. We can still take your calls at 1-800-955-8200. That is 1-800-955-8200. And I was talking before the break about trusts. And one of the things that sometimes people get so scared of probate that they start doing the things where they start gifting to their children, or they start adding their children to accounts just because they want to avoid the court process. And that is generally a bad idea. If someone adds the kids to their joint accounts, and then the kids get in a lawsuit or go through a divorce or get in a car accident, you can actually lose your money based on their creditors. So it's really a bad idea to start adding children and grandchildren to accounts. It'd be cleaner to make a payable on death designation where it's in your name, and then upon your death, it goes automatically to certain beneficiaries. Now, that's okay if they're all adults and you don't want asset protection for them. But I think it's often better to give in trust. Now, many people have more than one child, and they're not always the same. So I often say there's nothing as unequal as the equal treatment of unequals. Should I say that again? There's nothing as unequal as the equal treatment of unequals. Most people who love their family and their children want to provide in a helpful way, not a harmful way. So some children may need little divorce protection. Other children need complete asset protection and money management for the rest of their lives. In that kind of trust, you've got to list who's the trustee. And you need to, draft it with all sorts of rules and guidance and things like that. So one of the questions I get, Steve, what is a bare bones living trust, or what is a family legacy wealth trust? Well, a family legacy wealth trust is a trust that not only has provisions to avoid court while you're alive, but for married couples, it will double the tax exemption, and it will provide all sorts of protection, not only for the surviving spouse. You ever seen it where someone, after one spouse dies, the survivor remarries? Yeah, that happens an awful lot, and it often completely blows up or implodes estate plans. It can really wreak havoc. So a legacy wealth trust would have lots of protections, like a required prenup. So what if the one spouse dies, and then the survivor is about to get remarried, and they say, "What do you mean you want me to sign this prenup? Don't you love me? Don't you trust me?" Well, yeah, of course I want to get married. It's just that my first spouse didn't trust you. It's that my attorney, Steve Waltar, doesn't trust you. It's that my kids don't trust you. So that is a really, really nice tool to put in place. My parents had a wonderful marriage. They've been married, I'm 54 now. I turned 54 last week. So they've been married 55 plus years there. And they decided that they'd seen enough estate plans go sideways after one spouse died. And sometimes even older on in life, when people remarry, estate plans started changing. So they had me put in a required prenup. They do not want the surviving spouse to be able to mess up the legacy, the plan that they have for their children and their grandchildren and their charities and things like that. So that was a legacy wealth trust has what many revocable living trusts have as a way to avoid court, but it also has lots of protection for the actual heirs. And that's HEIRS, heirs, whoever would be beneficiaries of your plan. Let me digress and go backwards a little bit to just my week in planning. So this last week was interesting because it was my birthday. That was a lot of fun to have my birthday and do some things. I actually got to go to the Pac-12 tournament, And was that it? No, I got to see the NIT. That was the NIT game, the Huskies. In fact, I think the Huskies play again today at some point. So I did bring some purple. I'll have to wear it if we go out to watch the game. Oh, yeah, that was a lot of fun. I got to drive all the way to Tacoma and attend someone else's seminar. It was the Salvation Army. They gave a free wills and trusts. I don't remember the exact title, but they gave a really nice seminar. And there was a few questions they needed a little bit help from an attorney on, but they gave really good information. And I'd say they had, 70, 80 people in attendance down there. They do that a couple times a year, so I'm hoping that I'll be one of their speakers, maybe when they do that come in the fall. So they provide services if people want to do charitable gift annuities. The Salvation Army's got a really good one. But they were there just to educate people. What's the difference between a will and a trust? How do powers of attorney work? How do you set up title? And they also talked about designations, payable on death and transfer on death, things like that. So that was kind of fun to do that. March 15th, the Ides of March, not only my birthday, but that is a big day for people that have corporate returns. So if you own a corporation, your corporate tax return, or for many people that have S corporations, an S corporation is a corporation that is taxed at an individual level. It's often smaller businesses. My law firm's an S corporation. And I know many dentists and chiropractors and professionals have S corporations because there's some tax savings that you can have through that sort of an entity. Well, those returns were all due on March 15th. And even if you do extensions, if there's any taxes owed, those returns are due. Now, we have still with the tax season, you got to be thinking about the trusts. Trust returns are generally going to be due, those 1041s, the same time the 1040s are due. So this year, instead of being April 15th, I believe it's the 18th, it's that Monday because of a holiday in Washington, D.C. So taxes. I think that, Ben Franklin said nothing in life is certain but death and taxes. But then Will Rogers made a comment, and he says, yeah, but at least death doesn't get worse every time Congress meets. I think that's an important thing. When I'm giving talks, I tell people, look, avoiding taxes or avoiding probate may not be your biggest issue in life. The reason I started doing legacy planning is that I realized, look, you can avoid court or not, but unless you are protecting your assets for the next generation, you haven't been a very good steward. You have not cared for those funds really well. So legacy planning, on this show, we want to talk about what is a good estate plan. Who needs powers of attorney and healthcare powers of attorney and HIPAA authorizations? Well, most of us. Once you're an adult, you need that. A few weeks back, I had my daughter, Shelley Waltar, who does a lot of webinars. It's not webinars. She does podcasting and Christian gaming and things like that. And so we got calls, and that's why I know this show is live via the internet. You can listen anywhere in the world. Go to KGNW.com and click the Listen Live button. I had a caller from Pensacola, Florida. We had a caller from Michigan. And it was interesting. With a lot of the young folks out there, and actually when each of my kids turned 18, they didn't need a will. They didn't need a trust. But they did need powers of attorney. So again, legacy planning is just who needs what, when, and how do you coordinate it? So at our firm, that's what we do is we design plans. We design plans for individuals, for couples, whether a couple is married or not. People need planning. They really, really need planning. Actually, the married or not, that's kind of a fun story. So I met not that long ago with a couple. They had been together many, many years. I'll just say north of 20 years. In fact, they had been together a lot longer than some of their married friends who married and divorced, which is kind of a sad truth in our society. But at any rate, I advised them as to what sort of planning options they had. And I said, look, I could absolutely do a joint trust for you. We got to be careful about how we title things because we don't want to have gifting. If you are not married to someone, there's a limited amount that you can give each year. the annual amount is actually $14,000 a year, whereas if you're married, you can give an unlimited amount. So it can be a challenge to do a joint trust for a couple that's not married. So I told them, look, we could do separate trusts, we could do a joint trust, but we've got to be careful. And I'm going to have to be very, very careful reviewing the language. I'm going to have to change a bunch, so it'll cost you about $1,000 more if we do a joint trust. You can certainly do separate trusts, you can do wills, etc. But I told them what would be the fee if they wanted to get married, and I actually told them, look, if you were to get married, there's this, and this that would actually work a little more easier for you guys. And frequently, couples will agree. What happens when one dies? You've got a protective trust. Again, that's kind of a theme of this show, is how can you, instead of giving the money outright even to your spouse, why wouldn't you give it to them in trust? Because you can avoid estate taxes. You can avoid creditors. You can give them more benefits than if they owned it themselves, because of they can be the manager and the trustee and the beneficiary, but a creditor couldn't take the money. Well, anyway, I told them, look, it'd be $1,000 left if you wanted to do a joint trust. And then I think it was about a week later, I got a phone call, and I wasn't there to receive it, or I was in a consultation, but my staff says, yes, we're going to get married. And so I thought that was pretty cool that as an estate planning attorney, I went to seminary at Princeton Theological Seminary before law school, and I like to say I've got the mind of an attorney and the heart of a pastor. And this couple, they're going to get married, and I thought that was so cool. They obviously have a very good, strong relationship, and I hope that they get to celebrate with lots of friends and get married and do their estate plan. For my birthday, actually, I got a nice little card from my daughters who said, Steve, you've got or Dad, you've got the mind of an attorney, the heart of a pastor, and the will of a rower. So I have one daughter who's a rower at the University of Washington, which is, of course, the best rowing program in the nation. And I thought that was pretty cool because, yes, I get up at 4 a.m. 3 times a week, and I get to row for the Sammamish Rowing Association. My wife rows. We're kind of a rowing family, so that's I thought that was a cool little card. Mind of an attorney, heart of a pastor, and the will or the effort kind of a rower, which takes a lot of effort. So we're going to go to another break here, and then when we come back, we will keep talking about legacy estate planning.
Do you need a will or trust or no planning at all? You're listening to Legacy Planning with Steve Waltar. Join in the conversation at 800-955-8200. That's 800-955-8200. Legacy Planning. You're listening to Legacy Planning with Steve Waltar. Join in the conversation now at 800-955-8200. That's 800-955-8200.
Okay, so we are back. We are back on Legacy Planning. You've got Steve Waltar on Legacy Planning, and you can reach us anytime by going to radio@waltar.com. That is radio@waltar.com. That way we know that you heard us on the radio, and we can get back in touch with you throughout the week. In fact, I had a call. Actually, I called a prospective client because he had a question about an irrevocable trust. He's built up kind of a nice little nest egg, and his home is completely paid off, and he wanted to find out what can he do to protect his home. And so we had a brief phone call about that. That's not the sort of thing I can email back a reply, because it's not a one answer fits all. So during this show, we've talked a little bit about revocable living trusts. Remember, every trust has 3 people: trustors, trustees, and beneficiaries. And then you move assets into the trust. But what about irrevocable trusts? Okay, irrevocable trusts they have the basics. There's a trustor, trustee, and beneficiary, but frequently you either break up that group of 3. You set it up as the trustor, and then someone else is the trustee and the beneficiary. Then it gives you immediate asset protection. I like to say that trusts are an estate planner's golf clubs. There's different kinds for different purposes. So in that bag of clubs, you got the driver, and you've got the short wedge, and you've got the pitching wedge, and you've got your putter. So there's different kinds of trusts. So the most flexible, of course, are revocable living trusts, whether it's a single person or a couple. But irrevocable trusts can be very, very valuable. Let me paint a few different reasons for that. Some people are really concerned about making sure that the state of Washington will not put a lien on their home. What if they need long-term care? And they don't want to have to, if they run out of money and savings and things like that, the state of Washington will not care if you have a home. It's an exempt asset. But if you qualify for Medicaid and then you stay in the skilled nursing home for a number of years, then upon your death, what they're going to do is they're going to get repaid. It's called a payback or something like that. So one of the tools that we can do is we can do an irrevocable trust to take care of that. So an irrevocable trust or a midget or a Medicaid, an income-only trust, or there's different ways to structure it. But we can take your home, stick it in an irrevocable trust, and it's immediately protected from creditors. So if you get in a car accident the next week, they can't take your home. Well, that's one benefit. And then, of course, with Medicaid planning, at least in the state of Washington, it takes 5 years to be completely protected from Medicaid. So after 5 years, you still have the ability to live in your home, but if you had to do a Medicaid application, you have no reason to disclose that you made a gift because it's been more than 5 years. So a Medicaid trust is a really nice way to protect a home or a vacation home, and that's a great way to protect things. Now, if you are a veteran or a widow of a veteran, you can't have that kind of a trust. That would not work for you. Because if you've got an income interest or the ability to live in something, that's too much of an interest. So the Veterans Administration, they don't have a look back or a gifting period. They've talked for a long time about kicking in a 3-year look back. And that was supposed to kick in February 1st of 2016, but it has not happened. It hasn't happened yet. So it may or may not happen soon. But the main thing is you have to have a completely different kind of a trust. You can't have an income interest, whereas for Medicaid, you can. So that's, again, one of the benefits or one of the reasons you want to see a qualified attorney, someone like myself that has an accreditation to practice before the Veterans Administration. You will find the door-to-door salesman, often insurance salesman, and often annuity salesman. I have an insurance license, and I have since 2008, and I've never once sold an annuity. Now, I'm not saying that they're bad in all circumstances. I mean, an annuity can be a part of an estate plan, part of a strategy. But when you get someone that they make their entire living based on selling insurance and annuities, and they start bad-mouthing attorneys, you don't need an attorney, they're expensive, and this, that, and the other, lo and behold, they may tell you to put everything into insurance products or annuities, and yeah, they may qualify you for a VA benefit, but they probably completely messed you up for a future Medicaid benefit. And guess what? The Veterans Administration, the aid and attendance, it's a nice gap plan. When you get, from $11,000 to $24,000 a year, that's a benefit. But that's not really going to care for you if you've got $8,000 a month or $12,000 a month with skilled nursing home care and Alzheimer's and Parkinson's and all that sort of thing. So you need to, when you sit down, I would say sit down with a qualified attorney that can talk about this sort of planning. Yeah, I think that estate planning is a little bit of life planning. Indeed, we want to plan for, when I meet with people, I'm trying to decide what are their needs now? Who are their care providers now? Who should have their powers of attorney? Who should be able to make their choices for them? And we design a plan. Sometimes it's a standard revocable living trust. Sometimes it's a will plan. But sometimes you need one or more irrevocable trusts. You may need one that's a certain design and another one that's a different design. Yeah, life planning and estate planning, we absolutely do that sort of thing. So let's talk about just maybe two more examples of trust. So let's say that your estate is north of $2 million. You're a single person, your estate's north of $2 million, and you don't want there to be an estate tax when you die. Well, even though the federal exemption's over $5 million, but the state of Washington is just north of $2 million. So you could actually own insurance in an irrevocable trust you're not going to get it till you die, so why even own it? If you're not going to borrow against it or use it, don't be the owner. Well, that's called an ILIT, an irrevocable life insurance trust. And my firm is the trustee of a few of these, although it could be children, it could be others, it could be a professional firm. But as long as you are not the beneficiary and you are not the trustee, then the entire death benefit, you can have $1 million in an ILIT, and when you die, it's not subject to taxes at the state of Washington level, nor even at the federal level. So if you've got an estate that's above the exemption, if you're a single person and your estate is above $2 million, you might want to consider an ILIT. If you're a married couple, hopefully you have done planning to double your exemption. But what if your assets are north of $4 million? Then an ILIT would be a great way to avoid the extra Washington state estate taxes. And some people, singles or couples are north of the 5 or 10 million. So those are big exemptions. But an ILIT's a great tool. And then I'll mention one more, and that is it's called a Qualified Personal Residence Trust. A QPERT, a Qualified Personal Residence Trust. Let me just see if I can paint this out. So if you have a large estate and you wanted to lower the taxes, sometimes people don't want to give cash or they don't have cash, so they want to say, well, I just want to give my home to my child. We talked about that before. If you give something to the next generation, you lose all control. And so what if they lose it due to their lawsuit? Especially if you're living there, not only do you have to pay rent, but you could get booted from your own home. That's not a good plan. And there's a big tax problem. I have a number of clients that spent less than $50,000 on a home. Costs more to get a car these days sometimes, and now their home's worth $500,000, $600,000, $700,000, $800,000 or $1 million. If you give a house to your kid where your tax basis is, let's say, $50,000 and your home is worth $950,000, well, you have just given them your tax basis. And what that means is when you die, it's not going to have a step up in tax basis. They get what you gave them. You gave them your basis. You had to use up also, $900,000 of your lifetime exemption. But when you die, and if they eventually sell the home, they have to pay a big capital gain tax. So that's not very efficient. So here, that sets up why a qualified personal residence trust is really a nice thing. Let's say that maybe one spouse just died, and so that home is now, it's worth $900,000. It went from that $50,000 to $900,000. And so let's say that you say, gosh, I want to live in this home for the next 10 years. And then it goes equally to your kids, or it goes to your daughter, or something like that. So you do a qualified personal residence trust. You sit down with an attorney like myself. We design this plan. We figure out the term and all that sort of thing. And so then for the next 10 years, you are the trustee. You are the beneficiary. You're all three people. This is a really unique trust. You're all three people, and yet you've created an irrevocable trust. If you decided to sell the home and that 10 years is not up, you could buy a different home. And I won't get all technical, but you have lots of ability to do these things. But then what about after the 10 years? You've lived out the term, so now you need to pay rent. Fair market value rent to whoever is the trustee at that point. And often it's the children or something like that. And you say, gosh, why do I want to pay rent on my own home? Well, you don't do this unless you have a pretty good sized estate. Now, when you pay rent, that's not subject to the gift taxes. So if your rent is more than $14,000 a year, no problem. That is not a gift problem. But here's the real beauty. What if when you die, it's been 15 years and that home that you valued at $900,000, it's now worth $1.5 million. It all goes to the kids or whoever you said, completely free of estate taxes. Isn't that powerful? And the real benefit is when you did the gift, you look at how long the term is. And so let's, I said it was about $900,000 value of a home. What would someone have to invest to have it be worth $900,000 10 years from then? Well, the IRS helps us. And basically, every 10 years your asset is in trust, it cuts your gift tax in about half. So with a qualified personal residence trust, you're able to put your home in the trust, live in there the rest of your life, really, and live there rent-free for the term of the trust. And you were able to file a return with the IRS. It's a 709 gift return that I'll put you in touch with a good accountant. Again, legacy planning is not just us designing the right estate plan, but making sure you work with good advisors so that you can do the taxes, and so that your insurance, and so that, all of your ducks are in a row. So you file a return that you used $450,000 of your lifetime, $5.5 million exemption. And then you're able to live there and enjoy it and use it, and it's creditor free and all this and that. And by the time you die, it is out of your estate. It's not part of the tax formula. You got it out of your estate for the tax cost of $450,000, and when you died, it was worth $1.5 million. That is a really cool trick. And often people do this with their primary residence, or better yet, what about that vacation home? If you've got that condo in Sun Valley, or you got that family vacation home or something, it is a really powerful tool to do a qualified personal residence trust. So this section, we kind of talked about trusts, kind of the advanced plans, right? Irrevocable trusts. Remember, I said that trusts are an estate planner's golf clubs, different kinds for different purposes. I'm not sure what we want to move on to when we come back after a break here, but you can give us a call at 1-800-955-8200. We're going to take one more short break, and when we come back, we'll talk more about what is legacy planning.
Legacy Planning. You're listening to Legacy Planning with Steve Waltar. Is there ever a good time to do estate planning? Ask your kids. They'll know that right now would be the perfect time. Call in for the right answers at 800-955-8200. That's 800-955-8200. Legacy Planning. This is Legacy Planning with Steve Waltar, committed to helping you with personalized and compassionate estate planning. The lines reopen for your call at 800-955-8200. That's 800-955-8200.
We are back. We are back live with Steve Waltar at Legacy Planning. Legacy Planning is not only me doing estate planning. Our firm, that's all we've done is estate planning. We've got trained paralegals and staff, and we design plans. We design plans for individuals. But I learned many, many years ago. I've been doing this over 20 years. I've written 2 books on estate planning. Smart Estate Planning in Washington, which you can get from the UW bookstore, or it's actually in the King County Library System, and then Legacy Planning. Legacy Wealth Planning. There it is. I'll stare at it. That was done in 2012. Legacy Wealth Planning is really about designing a plan that works while you're alive, that works after you're gone. I often ask people, when are you going to know if you had a good estate plan? Well, you may never know. It may be the children or the grandchildren that get to know if you had a good estate plan. Well, what if I design a wonderful will or trust or estate plan, but the finances are completely messed up? The life insurance beneficiaries don't point to the trust. They point to beneficiaries. Well, the beneficiary gets a check for $400,000, and then they go through a lawsuit. There's no protection at all. What about your retirement funds? What if they don't route to the trust, they route to the children? Then they can be eaten up by bankruptcy, or they can be eaten up a lot of ways. So legacy estate planning is designing a really well thought through legal plan, but it's also making sure that your advisors and the assets all point to and support one another. And so on this program, Legacy Planning, I've had accountants, I've had enrolled agents who are accountants that have specialties in certain areas of the tax code. I like to get financial advisors on, but they've got so many broker-dealer rules and requirements. But I have had a couple of financial advisors on. I'm sure I'm going to go back and add Ron Gear, and we'll do more shows and talks about that. Because I want people that have a good core value. They want to develop the financial plan. And I think the financial plan should speak to the estate plan and vice versa. They need to support one another. We've also had a funeral director on the show. If you are interested in certain topics being covered, by all means, send us your request to radio@waltar.com. That is radio@waltar.com. Waltar.com. We are going to be doing a client appreciation seminar for our existing clients. That's coming up in April, and you can look at that on the waltar.com website. We're in the process of changing the law firm name from Stephen M. Waltar, P.S., which is a professional service corporation, to Legacy Estate Planning, LLC, just because it kind of describes what we do. So Legacy Estate Planning is what we do for a living. It's what we do for kicks. It's It's really what we like to do. So during the week, you can give us a call at our law firm number, which is 425-455-6788. That's 425-455-6788. And the other thing we're going to be adding to this show is sponsors, not just the speakers, but we'd like to kind of have some sponsors because it shouldn't just be me doing my own ads for my own estate planning. It should be for things that support this whole process. So if you are a local charity, if you're a person that thinks you have something in common with us, by all means, give us a call at our office, 425-455-6788, because I'd want to get to know you a little bit, go to lunch, do something, talk about it, see if we have shared values and goals. And then perhaps you could be a guest on our show, and perhaps you could be a sponsor. Well, my wife was giving me an idea about talking a little bit more about famous people. I think when we drive around town here, sometimes we'll run into famous people. And, of course, the slopes are named after famous people, Hemingway and things like that. So one of the benefits of revocable living trusts and trusts in general are privacy. So I'm staring at a slide here right now. This is Harry S. Truman, who had a 37% estate shrinkage. That sounds painful, doesn't it? Shrinkage, 37% shrinkage. So he lost a whole bunch of money based on estate settlement costs and death taxes. Well, that could have been avoided. Those sorts of things are Marilyn Monroe here, 21% shrinkage. So $20,000 of settlement costs, and her death taxes were over $154,000. Humphrey Bogart, 19%. Spencer Tracy, Franklin D. Roosevelt. He had a gross estate of just under $2 million, but he lost 30% because he didn't plan well enough. These are sad things. Now, sometimes you'll hear a story about Anna Nicole Smith and marrying a billionaire and then the fights and the estate disputes. When Bing Crosby died, he had planned with a revocable living trust. So we don't know who got his assets. We don't know what were the costs of administrations and this, that, and the other. It was all private. Whereas, again, we got these famous people. Dwight D. Eisenhower, yeah, we can see, actually, he did a pretty good job. Only an 18% shrinkage there. He had just under $3 million. Warren E. Burger. So that's interesting. Supreme Court Justice, he lost 30% of his estate. He's actually known for misspelling things in his own will and not having tax planning, which is crazy. That's an attorney who did a poor estate plan. That's the cobbler with poor shoes. So there are lots of reasons to do estate planning, and there are lots of benefits of trusts. Trusts are not for everyone. It's not my job to put everyone in a trust. It's my job to ask questions and learn about what someone's goals are. But trusts are private. So if you don't want people to know what you have or who gets what, when, and how, then a trust is a really, really fine way to do a bunch of things. I guess that's it. Oh, there's Ernest Hemingway there. Gosh, his estate was only $1.3 million. And it cost him over $63,000 in settlement costs, and then his death taxes were $188,000. So over $250,000 lost with the poor planning. Well, let's see. In my practice, I get lots of people that are concerned about the state putting a lien on the home, and a revocable living trust will not work for you in that, if that is your goal. If you want to make sure the state can't put a lien on your house, you can't do a standard revocable living trust. You can't even do a legacy trust. You would need to do an irrevocable, kind of a Medicaid trust. And it could be completely discretionary if you trust that trustee, or you might want to make sure that you have the right to the income. Now, sometimes people wonder, well, gosh, is that going to mess up the taxes on the home? Well, no. Actually, we can design a trust such that when you die, it'll still get a step up in tax basis so that what goes to your children actually goes with a new basis. So people that are doing Medicaid planning, they're not worried about saving taxes from the federal or state level. So we can make sure that if your home that was valued at $500,000 when you put it in, what if by the time you die it's worth $750,000? We can design a trust, an irrevocable trust that would step up in value, and then when the kids get it and it's worth $750,000, they don't have to pay a capital gain tax. So you've been listening to Legacy Planning, and we were just down into our last minute. I want to tell you that we do this for a living. You know, each week we're on the radio. We bring in various guests. We're happy to take your calls. Throughout the week, it's better to reach us at our office, which is 425-455-6788. That is 425-455-6788. Did I get that right? 425-455-6788. Or send us an email to radio@waltar.com. We would be happy to meet with you and schedule a free initial consult. In fact, if you want to meet with us, you can do it on our website or you can give us a call. And we will be happy to email you a free questionnaire and directions to our office. Thank you for listening. This has been Legacy Estate Planning. Have a wonderful, wonderful week. God bless.
You've been listening to Legacy Planning with local attorney Steve Waltar. If you have questions about what you heard on today's show or estate planning in general, be sure to call Steve's office in Bellevue to schedule your free no-obligation consultation. Call Steve at 425-455-6788. That's 425-455-6788. And remember, you can always listen to today's or previous programs by going to waltar.com. That's WALTAR.com. Have a wonderful rest of your weekend, and be sure to join us again next Saturday morning from 8 till 9, right here on 820 AM KGNW.